So this is the third recording of a reading from an emergency application to the United States Supreme Court pending the filing of a case for review of massive and systematic deprivation of breast cancer treatment coverage to women who are in a federal and state program. The government actually controls this cancer treatment program, and it creates great risk. And so I'm going to continue reading with the section on reasons for granting the stay. Quote, to obtain a stay pending the filing and disposition of a petition for a writ of certiorari, an applicant must show 1. A reasonable probability that 4 justices will consider the issue sufficiently meritorious to grant certiorari, 2. A fair prospect that a majority of the court will vote to reverse the judgment below, and 3. A likelihood that irreparable harm will result from the denial of a stay. That's from a 2010 U.S. Supreme Court case called Hollingsworth versus Perry. These standards are readily just satisfied in this case. Number 1, there is a reasonable probability that this court will grant certiorari and reverse the judgment below. That's in the Minnesota Court of Appeals and Minnesota Supreme Court on the instant cert petition, and also the appeal pending in the State Court of Appeals. As set forth in the petition, and I want to say that the clerk has said that the specific paperwork has to be appended to this application, and you can't just refer to the petition. But this refers to a cert petition that is U.S. Supreme Court case number 18-8511, which you can search for on the docket, and you can read that cert petition. So Stephen succeeded. That's me. I'm one of the petitioners. I'm the husband. In 2013, in securing 4 justices to grant certiorari and 5 justices to remand the case, Carlson Stephen W. versus Minnesota Department of Employment. That was 13-8124, United States from 2013. Back to the 8th Circuit U.S. Court of Appeals. The common issue with the instant case is that Minnesota was way off the beaten path in administering federal programs like Medicaid and unemployment. No one could take a case to a federal court to decide federal issues and federal rights. Everything had to be decided in Minnesota courts or administrative proceedings because of the 8th Circuit practice ended by Sprint Communications Incorporated versus Jacobs, 571 U.S. from 2013, which ended decades of abuse of Younger versus Harris, 401 U.S. 37 from 1971. So that's a long time. To bar any federal review of Minnesota agency actions or policies. So do you understand what that says? That says that Keith Ellison, Lori Swanson, all the Minnesota Attorney Generals, and all the Attorneys General in the 8th Circuit, I believe there's 8 states, would routinely bar any federal program, like for instance Medicaid or welfare. You could not get that reviewed in the federal courts if you alleged federal violations of federal law or constitution. So essentially, while Lori Swanson was over there beating all these Minnesota people in this program, she had the aid of the court's corrupt decision, because it was just a totally bad decision, reversed 9-0 by the case Sprint Communications versus Jacobs. So in Minnesota, this abuse was technically stopped by Carlson versus Emdeed, although that's undoubtedly thoroughly ignored by the courts in Minnesota. They don't care that they're not supposed to do that. No doubt they still go ahead and do it, and lawyers don't help. These people are pro bono lawyers. They're not even going to be allowed by the legislature to enforce these federal laws. Now, a number of laws and regulations were abused. In the instant appeal, one of the unconstitutional laws is that for all of human services, the Constitution cannot be discussed in the commissioner's hearings. That's Commissioner Piper, Emily Piper, and now Tony Lowry. And that is typical of what Minnesota is doing to eligible recipients of all federal programs, violating the Due Process Clause 14th Amendment. There's no counsel, and for the cancer patients, they are treated in an arbitrary and interfering way, violating their substantive due process, in this case with dangerous results and in violation of the Medicaid Act. So A, under this argument, the actions of Minnesota Commissioner denying coverage and denying payment pending appeal provide no benefit to women's health and are unduly burdensome. In Planned Parenthood of Southeast Pennsylvania versus Casey, 505 U.S. 833, 1992, Casey. This court began at 844, quote, "Liberty finds no refuge in a jurisprudence of doubt," unquote. In the instant emergency application and petition for certiorari, we are asking you to address the matter of liberty as well as right, and to relieve petitioners of the burden of ongoing long-term denial of payment of MABC benefits, that's breast cancer treatment benefits, while this long-term deprivation is on appeal. It has not been determined by a constitutionally adequate required procedural due process, and we strongly believe the interpretations and implementation of the Breast and Cervical Cancer Prevention and Treatment Act, BCCPTA, and MABC, Medical Assistance Breast and Cervical Cancer, violates Medicaid statutory requirements and is constitutionally flawed. This court addressed many liberties in Casey in an effort to examine what kind of burden the court has allowed on rights or liberties under the 14th Amendment. And I'm skipping footnotes here. But they said, as our jurisprudence relating to all liberties, numerous forms of state regulation might have the incidental effect of increasing the cost or decreasing the availability of medical care for any medical procedure. Only where state regulation imposes an undue burden on a woman's ability to make this decision, here the decision would be to complete their cancer treatment, does the power of the state reach into the heart of the liberty protected by the Due Process Clause, unquote. Clearly, where medical procedures are involved, direct interference by termination of coverage benefits, maintaining the same amount, duration, and scope of treatment supported by the high standard of treatment required by Medicaid law, provides no benefit to women's health and is unduly burdensome. Petitioners staunchly urged the court to see that this kind of reckless, legally unsupportable administrative practice for cancer patients, for whom the federal and state governments have taken on a direct responsibility through the optional coverage, must be weighed heavily by this court under the laws and Constitution. After nearly 3 years of termination and arbitrary interference from the agency, Ramsey County, and now the Commissioner and District Court, this undue and therefore unconstitutional burden must be controlled by application of law and the protections of the 14th Amendment, U.S. Constitution. Whole Woman's Health versus Hellerstedt, that's a 2016 U.S. Supreme Court case, held that the constitutionality of abortion restrictions, and we argue cancer treatment restrictions, enacted in the name of women's health or safety, are assessed under an undue burden test, in which the actual existence or non-existence of medical benefits is paramount. Such burdens are clearly undue when, as here, the law confers no health or safety benefit at all. As explained by respondents, the eligibility requirements in Minnesota Statutes 256B.057A were enacted for the invidious purpose of placing a substantial obstacle in the path of a person seeking to complete their prescribed and promised breast cancer treatment. The Minnesota Court of Appeals panel decision eviscerates MABC and its protections in sections 256.045 and .0451 by imposing unreasonable eligibility requirements, unquote, that provide no medical benefit and will restrict access to breast cancer care for the MABC patients. A grant of certiorari and reversal are reasonably probable for this reason alone. B. Denial of MA payments pending appeal unduly burdens the right to breast cancer treatment coverage and violates legal and constitutional protections. In WWH, this court held that where constitutional rights are at stake, courts may only credit actual benefits that are proven by evidence in the record. It strains credulity that a state seeking to ensure that the best interests of MABC patients are served, a basic tenet of Medicaid law, would turn to the ill-fitting, indirect approach of denying payment on appeal through judicial review, beyond the Commissioner's limited administrative proceedings in violation of Goldberg, or of arbitrarily denying constitutional rights against erroneous deprivation of MABC benefits by automatically transferring women from MABC to the elderly program with no benefits. Against this is some vague Schweiker interest, that Schweiker versus Hogan, a 1982 U.S. Supreme Court case, in reserving the dollars dedicated to cancer treatment coverage to completion for other purposes. So in other words, coverage to completion, and reserving those dollars for other purposes because of the assumption this will serve the most impoverished patients with no meaningful benefits for the cancer patients. Clearly, this is actually what Keith Ellison is arguing in the Minnesota appellate courts. Clearly, this burden on the MABC patients is undue and unjustified by the stated purposes. In fact, Barch, that's Judge Sean Barch, the district court judge in Ramsey County, concluded that the clear intent of the state is to impose initial eligibility criteria like age 65 as automatic expulsion triggers along the course of treatment, and that related statutory provisions in Medicaid and MABC may not even be read together as a whole, and that in fact courts are barred from inquiring into the purpose of these statutes. There is no sincere purpose in the state or the courts to implement a safe and optimal breast cancer treatment coverage program. Meaningful benefits cannot be provided, they say. The state's objective, this is for cancer treatment, no meaningful benefits. The state's objectives and approach as expressed, Commissioner Johnson Piper, are an undue burden on the effect of increasing the cost or decreasing the availability of appropriate cancer care for these low-income women, as the power of the state reaches into the heart of the liberty that is of life, protected by the Due Process Clause. I'm just going to leave this first argument, which is that the reasons why there's a reasonable probability that the court will grant certiorari and reverse the judgment in the Minnesota courts. I'm Steve Carlson. Thank you for listening. Hundreds of women are affected by this in Minnesota right now. We're asking for a moratorium until an impact study required by the Medicaid Act can be conducted to protect our women from cancer.